An update now to a story we discussed last week. A senior citizen in New York who fatally shot a would-be mugger in self-defense, it sure seems to now be getting the book thrown at him by a New York judge. 65-year-old Charles Foehner was arraigned Friday morning on 26 weapons charges. The judge set bail at double the amount initially requested by the Queens DA, $50,000 instead of $25,000. Why? Well, Queens Criminal Court Judge Jerry Iannisi, not sympathizing at all with Foehner, even though it was all captured on surveillance video at 2 in the morning. Last Wednesday, that's him backpedaling away from robbery suspect Cody Gonzalez, who's more than half his age and showing no signs of backing off, despite Foehner pointing a loaded handgun at him. And it was that gun that the judge addressed in court on Friday. Quote, "The defendant was on the street with a loaded, unlicensed gun. There are too many shootings in this city. The court is quite concerned with what we see." How about there are too many muggings in this city? Most shootings he's referring to don't involve defending yourself against a mugger. Foehner says he thought Gonzalez had a knife. Turned out it was a pen. And I'm not suggesting that Charles Foehner didn't technically break the law. In addition to the gun in his hand that night, a search warrant of the retired doorman and deli worker's home turned up over 24 weapons, all but 5 of them unlicensed. He's being charged with 26 counts of criminal possession of a weapon. But both the Queens DA and the judge had the ability to use their discretion here. I think they should have. Foehner is only in trouble because someone tried to mug him. He has no criminal record, unlike the man he shot, Cody Gonzalez, who had quite the rap sheet. 15 arrests dating back to 2004, including for weapons possession, robbery, burglary, drug possession, and criminal mischief. So why does it feel like they're taking every opportunity to throw the book at a guy who was defending himself? Back with us again, Mark Bederow, former New York City prosecutor and currently a criminal defense attorney. What do you make of this?
It's very rare that you would ever see a judge double the bail request for a prosecutor and, in essence, editorialize his own personal thoughts about gun safety issues like that. It's not an appropriate consideration for bail. The only issue before the court should have been whether this man was a flight risk. He apparently lives across the street from the courthouse where the shooting was. He's got no criminal record. He called the police. He is the one who actually self-reported, if you will, told them that he had the gun, told them what he had done, and appeared to be cooperative. And here he is getting just slammed by a judge who says there's too much crime on the street. It's just not appropriate.
Too much crime on the street, and he's the victim of a crime. I mean, that's the thing that's so puzzling about this. I also feel to some degree like the DA is throwing the book at him. Now, the 26 charges, right? You could argue, yes, if there were technically X number of weapons there that were unlicensed, but there's a way to deal with this, is there not, where you don't have to effectively throw the book at him?
Of course there is. I mean, prosecutorial discretion is the most important tool that any prosecutor has. When to do something. Just because they can doesn't mean they should. So in this case, by seeking that kind of bail, even the $25,000, I mean, the DA is signaling we want this man to fight the case from a jail cell. They want him incarcerated, and presumably if they indict him for these very serious crimes, then he potentially faces years in state prison.
All right, Mark Bederow, we're going to stay on this story. Thank you. Appreciate you coming in. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.